Okay, so obviously all of us who deal with progressives have run into someone who's not very happy about the prospect of suspension of regulations. And I changed it from pause to suspension because that is actually what is happening, and that is what is in the language of the bill. I can understand why those would call it as a pause also, but we'll go through the specifics of that. I don't think that's really important. The first thing to note is the only real reason for this regulatory pause is to get Republican support. Those of you who were at the last June's CCL Education Lobby Day heard Ted Halstead say very strongly that without regulatory relief in a carbon fee and dividend bill, Republicans would not support it and it would not pass. There's other things he wants in that bill, but this is the only thing he said that clearly and strongly. And so that may well be the case, and it certainly is the strong opinion of some. And as we know, Republicans do oppose regulations. They really support a lot of regulations, but they prefer to claim they oppose all regulations. But of course, they do believe that the unfettered free markets work best. And there is a school of very good conservative economists who support their position. So that is a reason for this being in the bill. Now, the CCL listed its rationale for this as, quote, certain existing greenhouse gas regulations would become redundant, conflicting, or duplicative by enactment of this policy. I'm going to slightly disagree with that. The economic book I read about this said that this works well with other regulations, subsidies, other policies, and that's one of the beauties of the carbon fee and dividend. And if a duplicate in regulations would double the speed at which, for example, coal plants went out of business, I would say that is a good thing, not a bad duplication. But so anyway, that's just my commentary. Now, it turns out that the authority and even obligation to reduce greenhouse gases comes fully from the Clean Air Act. That is the authorization. Of course, it didn't start out with that, and it was first passed way back in 1963. It had major changes in 67, 1970, 1977, and 1990. None of them related, though, to greenhouse gases. However, in April of 2007, the US Supreme Court ruled that global warming emissions are air pollutants and would be subject to EPA regulation under the Clean Air Act if a thorough scientific investigation showed that they endanger the public's health and welfare. So the law basically says that they should regulate any air pollutant that causes public health problems or harms to public safety. And so that is a broad commission, and the Supreme Court ruled that it does fit. Not long after that, President Bush issued the first executive order under the Clean Air Act, quote, to protect the environment with respect to greenhouse gas emissions from motor vehicles, non-road vehicles, and non-road engines in a manner consistent with sound science, analysis of benefits and costs, public safety, and economic growth. Now, his language is worth noting because the challenge of the Clean Air Act all along has been not only consistent with sound science, but also consistent with benefits and costs and economic growth, which has created a lot of challenges, especially for trying to implement greenhouse gas with the Clean Air Act. Since April of 2007, the EPA has been trying to affect greenhouse gases through the Clean Air Act, but as we know, they have not been highly successful. As the Supreme Court ruling mentioned, and as the law requires, they did do a study, and of course, the science determined that indeed, current and projected concentrations of the 6 key greenhouse gases, carbon dioxide, methane, nitrous oxide, hydrofluorocarbons, perfluorocarbons, and sulfur hexafluoride in the atmosphere threaten the public health and welfare of current and future generations. So this was the last step supposedly necessary for the EPA to begin its regulation of greenhouse gases. They proceeded to look for a few regulations. One of the main ones that they looked at and eventually passed has to do with new construction or major renovations of all facilities expected to emit significant amounts of greenhouse gases. And the concept that they have used since is that they are required to use the best available control technologies. And they're required to have a permit and state that. Now that is within appropriate cost parameters. And since throughout the Obama administration, it was basically believed that any new natural gas combined cycle power plant fits the best available control technologies to reduce greenhouse gases. And in late 2012, they actually completed issuing rules for these, and those have been implemented. And of course, there have been a few other things happen, but the next major thing was the Clean Power Plan, which was issued in August of 2015. And that was the only really significant effort by the Clean Air Act and the EPA to deal with greenhouse gases. Now, it was designed to do what I consider very modest, cut only electric generation, and that by only 32% below 2005 levels by 2032. So that's the annual emissions would still be 68% of 2005 levels by 2032 with the full implementation of that plan. And that's not total greenhouse gases, that's just the electricity sector. The main goal and philosophy was that natural gas was so much better than coal that if we just replace the coal plants with natural gas, with some renewables added in, we would be significantly reduce our greenhouse gases. Congress quickly passed a resolution of disapproval to this, and it was fairly quickly taken to the Supreme Court, and they ordered a halt to this plan, and it was the first stay ever issued before an appeals court had even heard a case. Part of this is because the Clean Air Act is ambiguous in its mission. It has plenty of grounds for being challenged. And so the Supreme Court, I guess, believed it could well be upheld. A few states voluntarily complied, and the implementation, though, was really held up in lawsuits until Trump took office, which pretty well has killed it. And in October of 2017, Pruitt did sign a proposal to repeal the Clean Power Plan. As with all EPA regulations, there's a period of time when they have to make the proposal, solicit comments, revise, and present. So even though it was proposed, and I don't think they've actually been able to complete the process yet, but I think we all know it's pretty much a done deal. Now, note that lots of lawsuits have tied up regulations to limit the greenhouse gases. The regulations are based on public health and must be balanced against economic costs, and that just opens a can of worms because there are no standards for how to weigh one against the other. all many lawsuits have to do is to hang things up in the court, and they can continue to run. As in Texas, we have a number of very old, very dirty coal plants, and they're already past their luck. If they can delay things 10 years, they've won. They don't even we need to win the case. So this has really limited the ability of the Clean Air Act to get much done on greenhouse gases. I also want to note that the Obama administration believed that moving from coal to new, more efficient natural gas plants would meet the Paris Agreement commitments that would lead to a significant reduction in greenhouse gases. They didn't understand at that time the issue of the methane leakage from fracked gas operations, which some scientists say significantly negates the amount of gain from moving to gas, because of the prevalence of fracked gas and its how potent the methane leakage is and how much it's so much larger than the EPA is currently saying. So the main suspension of regulations has to do with the Clean Air Act. Now, I didn't want you to trust me. I put the exact wording from the EICDA here, and what it says is if a carbon fee is imposed, and there's particular language there, with respect to a covered fuel, the administrator shall not enforce any rule limiting the emission of greenhouse gases from the combustion of that fuel under this act on the basis of the emission's greenhouse gas effects. Of course, that means that if it's not because of greenhouse gas effects, it can be limited. For example, if a huge production of nitrous oxide was determined to be causing an excessive amount of asthma, as it does in Dallas, the fact that it's a greenhouse gas doesn't help it any from being covered. Although I guess that isn't one of the covered fuels, but that would be a type of example. And the suspension ends supposedly, or could end supposedly, by 2030. Notice it doesn't say they have to wait that long, but they'll have to wait a while for a reason I'll note in a minute. And this is part of the EICDA. The administrator shall make a determination by March 30, 2030, whether cumulative greenhouse gas emissions exceed emission reduction targets. And if so, subsections A and B, which have to do with the suspension, shall cease to apply, and the administrator shall issue such regulations as the administrator deems necessary to bring cumulative greenhouse gas emissions to at or below the emission reductions target. Now, if they determine that for several years we've been falling short, they have to make up any that was added extra so that the cumulative amount fits the targets in the bill. Note that these regulations to be imposed to bring down greenhouse gas emissions does not have the ambiguities nor the balance this against the economy that the Clean Air Act has. So if we get to that point and regulations are needed, it is less likely that there will be successful court challenges. It is a much stronger type of position given the way the law is written. So what is suspended is what is in the Clean Air Act. And I originally have been telling that nothing was actually suspended, and I was able to find out there actually are a couple of things that are suspended, although they're not that significant, I don't think. Of course, the Clean Power Plan isn't technically dead because the process is still going on, but it's already dead, and this would have completely suspended that too. but I don't think that's an issue. They do have some regulations for new power facilities and also from industrial facilities which are new or significantly modified that are required to use what is called best available control practices. Now, this only applies to new facilities, and there's reasons to use many of those best practices anyway. And if it emits any other than greenhouse gases, other pollution, they can be required to. But anyway, these are currently in effect, and they are not. They are going to be suspended. The other one is there is a federal low carbon fuel standard. I don't really know its full status, but I believe there is one in effect. In a low carbon fuel standard, which California has a good one, requires a portion of the fuel to be low carbon. Now, at this point, most of that low carbon fuel is from biomass. They do not count the carbon in fuel if it is a biomass process, because the idea is it was pulled by the plants out of the air and sent up, and then it'll be pulled back out of the air to be sent up. Therefore, things such as ethanol from corn will fit that. And as probably most of you know, there is some questions as to whether or how much ethanol really and biomass really reduces our carbon emissions. So it is true that these regulations made it very difficult to build new coal plants since they've been implemented, and it led to a slight increase in efficiency in some facilities. But I would say that it's had almost no effect on really reducing greenhouse gas emissions. One note about the coal plant. There has been a new one since 2015. It's one built by the University of Alaska Fairbanks. And they were able to build a coal plant, even though that's generally not considered a best available control practice, because they have no access to natural gas, insufficient wind, and too little sunlight for too much of the year. And they had to meet those conditions to even get approval to build that. And they are close to a coal mine. But that is the only new one that has been built since 2015. And as we know, several hundred have been retired. So I don't think this regulation is needed for coal. I doubt any of you do. It's just not economic to build a coal plant anymore. So the EICDA also has some specific exceptions to the suspension. And I wanted to go to the original language again to track down all of that to make sure we had everything covered. Okay, so it does indicate that if you are limiting the emission of any greenhouse gas because of any adverse impact on health or welfare other than its greenhouse gas effects, you can do so. So if the same regulation were to use as its reason not to cut greenhouse gases, but because this would improve the city's health, that is allowed. This number two here, in limiting emissions, to consider the collateral benefits of limiting the emissions because of greenhouse gas effects. Now, what this is saying is, if greenhouse gases have a collateral effect of worsening situation, and by cutting those greenhouse gases, you have a collateral benefit to health, you can still do a regulation. A third listed exception is you do not suspend any regulations that limit the emission of black carbon or any other pollutant that is not a greenhouse gas that the administrator determines by rule has heat trapping properties. Now, note that this is still going to be under the Clean Air Act, so they would have to make it past other hurdles, including court challenges. But in our bill, at least, it does not. It accepts. They could still take care of black carbon or anything else that would trap heat. And fourth, they basically, any other action other than limiting its emission, and especially they want to continue to allow regulations to gather information, monitoring, reporting, investigations, and information collection. So these are the specific things mentioned in the EICDA bill that are exceptions to the suspension. Oh, I'm sorry, there's another group. It also explicitly names that the corporate average fuel economy standards for autos are accepted to the suspension. They will, they can continue. They are in effect. I believe that Trump is weakening them, but that's a valuable thing. And there have been recently imposed some light duty vehicle fuel efficiency standards, and those are exempted. And then there are some on aircraft engine efficiencies, although they can't be more stringent than the standards adopted by the International Civil Aviation Organization. All right, the next two, I think I understand, but I would almost have to consult a clean air lawyer to really be sure. But I got this exact language from Part 60 of Title 40, 0000 Code of Federal Regulations. And what it says is that this part that is exempted relates to, again, that those best practices relative to new or modified reconstruction of facilities that have to do, in the first one, with volatile organic compounds and sulfur dioxide emissions. And the second one has to do with the limitation on emissions of methane. Okay, so those are this is language in the EICDA. And this is everything they mention relative to suspending regulations and to exceptions to suspension. Note that the CCL community says that these last two mean that EPA retains its full authority over greenhouse gas emissions from natural gas and petroleum systems, except natural gas processing plants, emissions from which are taxed under Section 9002, and from publicly owned sewage treatment plants. That's true. I don't have that here, but I noticed that there is an exception to publicly owned sewage treatment plants. I'm sorry, I think that's a part of this OOO and OOOA, but that is another exception to suspension. I'm not sure the EPA retains full authority, but the CCL experts probably know more than I do. So that is the facts as I could determine. And then we have the challenge of answering progressives who object to the suspension of the greenhouse gas regulations. Now, some of the reasons I give are pretty straightforward. One, it really affects no significant current regulations. The only two things that it might have done is the Clean Power Plan and new coal plants, in my opinion. Someone else. So basically, I will no longer say it affects no regulations, but it really doesn't affect any that have to do with much. And if any have a different opinion, I really want to hear your opinions. It also only affects regulations to cut greenhouse gases from burning fossil fuels, which, in fact, a carbon fee and dividend reduces better. Regulations are not nearly as comprehensive as a carbon fee. in affecting decisions to reduce the burning of fossil fuels. Another thing to note that people don't realize, this does not prohibit any regulations of greenhouse gases until 2030. It prevents the administration from passing any regulations based on the Clean Air Act. At any point that Congress wants to, it can pass any regulation it wants, including amending the Clean Air Act or the Energy Innovation and Carbon Dividend Act. So this does not shackle what is going to, what people want to happen. If there was a huge movement to pass the Green New Deal and the Green New Deal needed to have some regulations in it, there would be no problem with that. The challenge is, of course, in getting the stuff passed. Fourth, many regulations, and this is a point I would make, are still permitted under the Clean Air Act that have to do with greenhouse gases. Actually, there are issues that I think would be better served by regulations. For example, methane leakage from fracking sites would be very hard to do with something like a carbon fee, but it is very possible to pass regulations to make sure that happen. Black carbon reduction. You could even shut down coal plants due to the air pollution health effects, which are, as we know, severe in a number of cities, and unconscionable that we continue to let those coal plants operate. Another argument that I would make is that the EICDA does require strong direct regulations if targets aren't met. And if they need those regulations, they have a clear authority for those, which it would be less open to legal challenges. Now, the targets in the bill only start in 2025. It reaches 30% in 2030. So that would be, in 2030, it would need to be 30% less than the emissions level of 2016. And by 2034, it reaches a healthy 50%. I personally am disappointed that these start as late as they do. I would have a stronger case with my progressives if the targets started much earlier. They're aggressive enough during their first 10 years once they start, but I hate to wait another 5 years. And I don't think we'll need this personally, but it would be, if this is to be a valuable fail-safe, I sure wish it started earlier. But again, that's my opinion. Okay. Virtually everyone agrees that a bill that would directly address climate change would be far better than trying to use regulations via the Clean Air Act, which wasn't designed for this. And the final point that I sometimes make, that regulations could work fast, but if we had a rapid change in greenhouse gases, that it would have effects on the economy, and I think it could lose popular support. The experience in France with their Yellow Vest movement is an indicator of that. Now, I want to raise one concern about the suspension of regulations. If we indeed get a president elected in 2020 that supports climate change action, and we do not have a majority of the Senate or enough of the Senate in order to pass bills, if we do pass this bill, I think it will do a lot of good. I suspect it will do more than we could get done on the Clean Air Act. But in that circumstance, we would be removing the only other tool that president would have to try to reduce greenhouse gases. And so that's my one comment, a word of caution. I can't, surely we will have enough people, and I think we'll be getting people from both sides of the aisle by 2020. And so this is a word of caution, but not something that I think is a high degree of fear. Okay, so that is what I have, and those are my responses, and I would very much like to hear other people's ideas about how they would respond, if you have any.
Yeah, hey Bob, this is Dave in San Francisco. Can you hear me?
Yes, I can, Dave.
Okay, cool. I think one other thing you could say to progressives is a great list of responses that we can make. But remember also that during that regulatory suspension, annual reviews, whether we're meeting targets, are still happening. And during that time, if we don't meet targets for like the past year, the fee increase can go from $10 to $15.
It was my understanding that we have a target of 0 until 2025, and then it starts to be 5% below. We have to wait until 2025 before we could implement that 15 instead of 10. And then you are absolutely correct. Once we get to that point, in 2026, we can see if 2025 was 5% below 2016. If it's not, then it goes to the 15. But you're right. Since there's so much concern among the progressives I talk to about dealing with this more quickly, yes, that's a good point to keep in mind, and it certainly is part of the teeth to do more later. But since it can't be implemented until 2026. I don't tend to mention that, but that's a good point. Thank you for adding that.
So you're saying
okay,
10 to 15, I mean, it doesn't cover that entire first 10 years. It just covers the tail end of it, or what?
There's a chart for targets.
Yeah,
and the first year is 2025. And so they can look and see if we met the target in 2025. But for the first 5 years, there's a 0% target of reduction that we can work with. And so it is my understanding, and if anyone else has a different understanding, please speak out. But it's my understanding that we can't use that for until 2026, I believe.
Well, that would make sense. Yeah, if the targets don't start till then.
Yeah, and I wish they started immediately. I would. That would make this, with its teeth, that would just really make this a powerful bill to progressives, I think.
I wonder too, before I go, I wondered if you or anyone on the call knows the answer to this. A response that we can make to the Green New Deal advocates is that our bill will reduce emissions at least 40% in the first 12 years. And of course, the Green New Deal folks are looking for that. Of course, if it passes this year, it's 12 years till 2030, right? And that's what the Green New Dealers want is 45% by 2030. But here's the difference. The Green New Deal idea uses 2010 emissions as their baseline. Well, in fact, that's what's in the IPCC, I think, as calling for 45% reductions from 2010 levels by 2030. In our bill, the baseline is 2016. Does anyone know how 2010 emission levels compare to 2016 emission levels?
They're higher. I don't know. They're higher. So 2016 is a more stringent benchmark because we're reducing our percentage of a lower number, which gets us to a lower. Oh.
You gotta come up here.
Oh yeah, I was answering you. Yeah, the emissions were higher in 2010 So reducing to 50% from 2010 would be a higher number than reducing to 50% from 2016. So our benchmark is actually more stringent benchmark.
That's my understanding too, but it's not significantly different, but it is more stringent.
Okay, great. So our response that our bill would reduce at least 40% in 12 years. That's a good response to Green New Dealers who want the, 45% by 2030.
Well, the Green New Deal isn't well designed yet. Alexandria Ocasio-Cortez's version wants 100% by 2030, and others have much less aggressive and more achievable goals. But make sure you're aware that they're thinking that we've got to do it 100% in 12 years, not the 50% that the IPCC has called for by 2030. But yes, I am working hard to present to spread the idea that this is consistent with the Green New Deal. It gets a head start. It could help other stuff pass. And the Washington Post had a full editorial staff opinion that a better Green New Deal would be to start with the carbon tax and then add the necessary regulations. That's something worth tracking down and reading, because it was a very interesting and strong piece. So the Green New Deal isn't fully defined, but the Sunrise Movement and Alexandria Ocasio-Cortez's versions does call for 100% by 2030.
I have a thing that has worked really well for me to mention. I guess I should ask to verify, if you could verify this. I mention a lot that this bill has 9 times the reduction in emissions that of the Clean Power Plan. Is that a number you have heard that you can confirm?
Yes. Yes.
Okay.
That's a very good response. Yes.
And then I just mentioned that basically we have the strongest, most comprehensive legislation ever to be introduced, and that we're hitting 40% at 2030, 90% by 2050. No other legislation comes close. The second to that would happen trade in California, which comes close at 80%, but of 2005 levels, not of 2016 levels. And so making that point has worked really well with the environmental groups that I've been talking to.
Excellent. Yeah, I was not trying to come up with answers to all reasons of why this is the best bill, but I was looking more in this presentation at the regulatory piece of it. If someone is saying, I can't support that bill because it suspends regulations. And of course, as you probably know from your experience, when people say that, they think it is a much broader ban on regulations than it really is. And that's definitely the first place I start, is to make sure they understand it's not covering nearly as much as some people are afraid or are claiming that it will. Thank you for that input. Any other comments or questions?
So what I got was that 2010 emissions were higher than 2016, right?
Yes, especially carbon emissions. I don't think we have adequately captured all of the methane emissions. Someone else may know better than I on that issue, but I believe that what they were saying was, for a while, at least until the last 2 years, we'd hit a level point and we're slowly going down, as first because of the recession and then because of coal plants going out.
All right.
Bob, this is Claudia again in St. Paul. Could
Yes.
you repeat your point on the ambiguities in the Clean Air Act that limit the effect and the scope it has on greenhouse gases?
Okay, it was originally passed to stop air that was breathed in and cause health problems. It had a general charge to reduce those, but to keep in mind cost benefit analysis and economic issues. Well, if they pass something and someone says, but what you're doing is your cost benefit analysis is all off. Yeah, it benefits the health of these few people, but it'll put 1 million people out of work. Then obviously it's not a good cost benefit. So they can take it to court and tell the court, hey, they misapplied the law. We're not, don't let them do that. And frequently the courts will say, okay, while this is under adjudication, we'll suspend the rule. And so one of the tactics, and quite frankly, the Sierra Club has used it against Trump. One tactic is to tie things up in courts so that changes in regulations or proposed regulations can't go in effect. And so that is a part of the reason is the mixture of goals that have to be considered. And the other piece of it is the fact that it is directly looking at the health of people from air pollution. And it's done a great job. I mean, it could do better, but it has done a lot to keep our air from getting dirtier than it is. But it does, when you apply it to greenhouse gases, the Supreme Court did indeed rule, yes, that is an air pollutant that has a health problem. But when they go to specific rules, then they say, well, no, you can't just go to any restaurant and say you're releasing greenhouse gases and that's going to hurt public safety, so you have to stop it. There's a lot of what their actual full scope is never been, I believe, totally defined and probably never will be.
Bob, just to underscore your point about things getting tied up in regulation, the Clean Power Plan is the perfect example of that. I mean, it was essentially the result of that. So it really is a tough road to go with regulation.
Yes, and so unless it's really clear, and again, when you look at the EICDA, that is clear. There's no question that they would have the authority. They don't say if it doesn't cause any economic problems, then you'll cut the greenhouse gases. It says if it does not meet those standards, you must do regulations sufficient to do it, and that is a clearer mandate. It is a very specific mandate instead of a general mandate, and that's much easier to defend in court.
This is Claudia again in St. Paul.
Yes.
And, this is more a comment about how people feel than about the real details of things. But I wonder if there's a reluctance on the part of some progressives to embrace our bill because they feel, and this regulatory pause or suspension, because it feels like losing something that we've got, in like a bird in the hand is worth two in the bush kind of thing. Yeah. It's sort of like, well, it may be weak and it may be, blah, 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 but it's something we've got. So
that's a good point. And being able to tell them there's only a couple of really minor rules we would lose is very helpful. I mean, Trump has already killed the Clean Power Plan. This won't really have any effect on that. And I think that when I tell people that, they say, oh, okay. They're not as concerned about it. This is not the major concern I run into but it is one I run into, especially among environmentalists who actually were working to try to pass the Clean Power Plan and the cap and trade, and they've been working on that stuff for a long time. And of course, regulations have done us are a way to bring certain problems under control, and so that's a it's more of a subset that is more concerned about that. Most people don't even know about that provision within the EICDA, at least that I talked to.
Hey, Bob, this is Tamara. Can you hear me?
Yes.
I just wanted to share, well, first of all, thank you for that. That was a great, concise, and clear presentation.
Thank you.
This is really a big issue, and I appreciate you tackling it. And I just want to share with you and with everybody else on the line who might be interested. Recently in Portland, we have been putting together a resource document that does our best to list out all of the key links and resources on CCL's website. So the community forum, the Q&A, the Energy Innovation and Carbon Dividend Act website, specifically regarding regulatory adjustment. And also there's another document that Iona put together in the Northeast with sort of the preambles to that in regards to how do we respond. I think that the important thing is that we figure out what the concern is of who we're talking to and consider the listening approach that of the CCL way, and listening and validating, finding out what the concern is, and then responding piece by piece. So anyway, we put together 2 of these documents. I'm going to put the link to the one we created in the chat if people want it.
Okay.
It's a work in progress.
I will post it on the Progressive Outreach forum also, and so people can access it that way. If it's okay, I'd like to copy it into our Google Drive so people can see it.
Sure. Yep. It is a work in progress. So it's.
They all are. Everything we do is.
Great. Thanks.